Alrighty, party peoples of the interwebs, there's an expression on the internet typically used in reference of politicians and the media. No matter how much you hate them, you don't hate them enough. That is equally true of Disney. Now, this story has been making the news, sort of going viral, and I've always said that when something goes viral, it's because it taps into a basic human emotion, either of joy or of hatred. In this particular case, it's tapping into the emotion of hatred, because if you didn't hate Disney before this, you are going to hate them after this. Before we even get into the story, although I look like a crazy dude with unkempt hair screaming at a camera from his car, I used to be a practicing attorney up in Quebec, behind the Iron Rainbow, the Maple Gulag. I was sworn in 2007, and I practiced for over 13 years, active practice. Despite my current unorthodox look, I actually have meaningful litigation practice, and I am able to understand this case for what it's worth in law, but it's going to make you want to puke, in fact. The story starts off with a woman who is extremely allergic to peanuts and milk, eating at a restaurant. It's called, I forget the name of it, we'll get to it when I read through certain passages of the lawsuit. Eating at a restaurant on the Disney premise. Disney is in fact the landlord of this particular restaurant. This restaurant prides itself and boasts about being sensitive to food allergies, and Disney itself on its own website prides itself on the fact that this restaurant is sensitive to allergies. This woman goes to the restaurant, explains to them that she has a severe peanut and milk allergy. She eats there with her husband. About 40 minutes after the dinner, she begins to have a severe anaphylactic response to something that she ate, apparently, and she passes away, and it's found that she had in her blood levels that would indicate that she came across some food that contained peanuts and or milk, and she died. She died as a result of the meal that she ate, allegedly, at this restaurant. Her husband, for and on behalf of his deceased wife, sues the restaurant, sues Disney, and Disney makes a motion to compel arbitration, meaning to take this case out of the courts and bring it before arbitration, because the man signed up for Disney Plus and clicked on one of those "I agree to the following terms," a so-called Clickwrap agreement that stipulated that any and all disputes that can arise, including involving the minor children or persons that the individual clicking on this Clickwrap agreement represent, that they shall be submitted to binding arbitration. And Disney is now arguing that that should also include the wrongful death of the spouse of the individual after eating a meal at a restaurant on a Disney premise that is a tenant of Disney, that Disney warranted made meals that were sensitive to people's food allergies. Motion to compel arbitration and stay case. Defendant Walt Disney Parks and Resorts US, WDPR, under the Federal Arbitration Act, FAA, moves for an order 1 compelling plaintiff Jeffrey Piccolo as personal representative of the estate of Kanakporn Tangswan to arbitrate all claims against WPDR, and 2, staying the action pending arbitration. Introduction. This case involves an allergic reaction the decedent allegedly experienced after dining at a restaurant called Raglan Road Irish Pub and Restaurant located in Disney Springs. Raglan Road is owned and operated by defendant Great Irish Pubs Florida Inc. WDPR leases the property to Great Irish Pubs. The complaint alleges an agency relationship between landlord and tenant. But the only facts supporting this theory are, quote, representations, end quote, about Raglan Road's, quote, allergen-free food, end quote, on the Walt Disney World website. Piccolo alleges that he relied on the website in choosing to dine at Raglan Road, but Piccolo ignores that he previously created a Disney account and agreed to arbitrate, quote, all disputes, end quote, against, quote, the Walt Disney Company or its affiliates, end quote, arising, quote, in contract, tort, warranty, statute, regulation, or other legal or equitable basis, end quote. This broad language covers Piccolo's claim against WDPR. Because the parties agreed to arbitrate these claims, the court should compel arbitration and stay the proceedings. No matter how much you think you hate Disney, you do not hate Disney enough, and I think there are something like 156 million worldwide Disney Plus users out there. I think that number's going to drop wildly, and understandably so, after reading this motion. Page 3, Piccolo accepted the Disney Plus subscriber agreement. In November 2019, Piccolo initially created a Disney account through the Disney Plus website. Piccolo completed the registration web form by providing personal information, including his email address, and created a password. Immediately above was a disclosure notifying Piccolo that, quote, by clicking agree and continue, you agree to our subscriber agreement, end quote. Piccolo then selected, quote, agree and continue, end quote. The term, quote, subscriber agreement, end quote, was underlined in blue font and provided a hyperlink directly to the document. Piccolo also agreed to the Disney terms of use. Piccolo could not have created a Disney account without doing so. The lawsuit then goes on to allege that the terms of use contain a binding arbitration agreement which would submit any and all disputes under the sun in perpetuity throughout the universe to be submitted to binding arbitration, even if that includes a wrongful death at the restaurant of a tenant of Walt Disney. Now, one thing that I can tell you as a former practicing attorney, I did a fair bit of arbitration. One of the biggest cases I had involved binding arbitration. It was an amazing learning experience. You learn that arbitration agreements tend to be interpreted very broadly and afford to the arbitrators the power to determine if they have jurisdiction. That is to say, the arbitrators will decide if they have jurisdiction over a specific matter. So the courts tend to interpret arbitration agreements very broadly and say, we'll send it to the arbitrator will decide whether or not they have jurisdiction. So other than being a wildly unpopular and I would say business-wise devastating move to make, it's not untenable in law that a judge says, all right, look, I don't really want to, but I'll submit this to an arbitrator. The arbitrator will decide whether or not they have jurisdiction. And if the arbitrator determines they don't have jurisdiction, they'll kick it back up to the courts. At page 6, first, the Disney terms amount to a valid and enforceable, quote, Clickwrap agreement, end quote, which required Piccolo to assent by selecting, quote, agree and continue, end quote, before proceeding. Florida courts recognize such agreements. Second, the Disney terms delegate all issues of arbitrability to the arbitrator. This means that the arbitrator determines nearly all challenges to an arbitration provision, including its scope and enforceability. Finally, WDPR has not waived the right to compel arbitration since it has barely participated in litigation. We explain each of these points below. We don't need to go into it in detail. You get the idea here. Disney is saying, let's bring this all to arbitration, including the claim against the restaurant, until it can be determined who has jurisdiction, and they're going to rely on that Clickwrap agreement. And get this, it doesn't even matter if Piccolo didn't read it before clicking agree and accept. Whether Piccolo actually reviewed the Disney terms is also immaterial. These Clickwrap agreements, like the Disney terms, provide users with inquiry notice. This conclusion is strengthened because Piccolo kept using WDPR's website and purchased tickets after receiving the Disney terms. Under Florida law, valid contracts are also formed by a party continuing to use services. That is the gist of the argument here. It's not untenable. Although this position is wildly, disgustingly unpopular, and understandably so, it is not wildly untenable in law. We'll see where it goes. The judge has yet to issue a ruling, and I suspect that this case will probably settle at some point in the near future for an acceptable amount to the family of the decedent. But this does illustrate the idea that when you click on these Clickwrap agreements, really you have no idea what you're agreeing to. You submit everything to arbitration. Arbitration is good in a sense in that it's confidential. Typically speaking, it's confidential, so it's good for the party being sued because instead of airing out your laundry in an open court of law, you do it confidentially before an arbitrator. These arbitrators tend to be retired judges, so in theory they have some legal expertise, although it sort of seems to be baked in favor of the party requiring this to go to arbitration. Depending on the jurisdiction, arbitration tends to be not susceptible of appeal because you're bypassing the courts. That's the purpose of the arbitration. But the idea that people could agree to submit everything to binding arbitration, anything and everything that results from having clicked an online agreement to a Disney Plus subscription, especially when the claim results from an alleged wrongful death at a restaurant, I mean, that's going to irk some people, and understandably so. And while Disney might succeed in law, even if they get it submitted to an arbitrator, they're going to suffer the consequences in business because people are going to rightly and understandably so vote with their dollar, cancel their Disney Plus subscriptions, and get the hell out of those binding agreements. We will see where it goes. I will talk about it Sunday night with Robert Barnes during the Viva and Barnes Sunday Night Law Extravaganza. If you like what I do, be sure to like, share, subscribe. Make sure your notifications are turned on so you get a notification whenever one of my videos goes live. Drop the comment thumbs up thing. If you like the video, thumbs up. If you don't like it, thumbs down. Let me know why. Share my stuff with someone who you think would like it, and share it with someone who you think would not like it because they might need to see it more. More important than anything, exercise, eat healthy, get outside, talk to people in real life, and now you know your vlog. Peace out, peeps. Booyah! Oh yeah, one final thought that I forgot to mention in the video. Disney's asking that this be submitted to binding arbitration and that there be a stay on the court proceedings, not just against Disney, but against the restaurant itself. And the question is, how could they ask for a stay of the proceedings against another party? They raised the argument that there is a risk of contradictory judgments if you have parallel proceedings, one against the restaurant before the courts and the other against Disney if this goes to arbitration. So you need to state all of it. Again, possibly a very unpopular position, but not one that is totally untenable in law, because it is conceivable that you could end up with contradictory judgments if this follows the court system against the restaurant and arbitration against Disney. But just to clarify that one last point in case any of you were thinking it, and that's it. That'll end the vlog for real now. Check it out. Peace.